There are some areas of law which can be taught to you by hundreds of good teachers. You can watch thousands of YouTube videos, you can read a lot of theory, but you need a perspective of somebody who's practicing law to better understand that kind of a provision. And one such provision is section 313 of CRPC. Hello everyone, this is Advocate Isha Kapoor and you're watching Vlawgish. So Supreme Court recently summarized all the principles related to section 313 CRPC. While you may call this a landmark judgment, but I'd better like to describe it as an amalgamation of all the landmark judgments, as a summary of all the landmark judgments that the Supreme Court has given. In fact, even last year in August, a three-judge bench of the Supreme Court, led by Justice N.V. Ramana, had given a judgment which was fantastic on the topic. So here I am dividing this video into few parts. First, we will talk about section 313 CRPC. We'll not talk about the theory of it, but we'll try to understand it in a better manner. Second part, we'll try to understand the meaning of these words may and shall with respect to this particular section. And then connecting from these two words, we'll try to understand the kind of questions the court, the judge may ask you or your client if the stage of your case is at section 313 CRPC examination. So there is a whole examination that happens under this section by the court, either in the written format or in the oral form, and we'll talk about it. In the later part, we will discuss a few questions, a few queries that often are asked with respect to section 313 CRPC. Before we go any further with section 313 CRPC, I know that there are a lot of people on this channel who are watching this and are currently either school students or know students from school who wish to prepare for the CLAT exam or who have dropped for the CLAT exam. This is a wonderful opportunity for you. You can avail scholarship. Tomorrow, 13th of March, 2 p.m., there is a mock test which is being conducted by an academy. If you're a good scorer in that mock test, you can avail up to 100% scholarship and prepare for almost free for the CLAT exam and the AILET exam and even the MHCT exam or other such law exams. If you think that you do not want to give this mock test right now because you're already preparing for the MHCT exam that is very near, it's in April only, and you quickly want a crash course for it, then also there is an option for you because there is an amazing discount going on the MHCT crash course. It's just for 5,000 rupees and it's worth it. If you study all the material that is being given to you by the educators properly, mark my words, you'll be able to get into a very good college from the Maharashtra. Moreover, if you were thinking to buy a subscription, to go for an academy subscription for your CLAT or the AILET exam, then go for it right now because for a very limited period, there is up to 30% discount going on. If you take the Unacademy's iconic subscription for CLAT right now, you can save up to 25,000 rupees, and that's a lot if you're preparing for an exam. You just have to simply go to the link given in the description box, use the code Vlawgish whenever you ask for that code. If there are any QR codes, I've already given that on screen. So if you want to prepare for the CLAT exam, do register for the CLAT mock test that's tomorrow. And if you're already preparing for the MHCT or the CLAT exam, then I've already given you amazing batch options that are available on Unacademy. Do not wait any further. I have to continue the video because I have to tell you all about 313 CRPC in great detail. But you please go to the link given in the description box. See if this course will benefit you. I have the CRPC Bare Act in my hand, and if I go to section 313 CRPC, I can very well see that there are 5 subsections, but the most important subsection I'd say for you to understand is subsection 1. It also has 2 parts. So I just tell you what this section is in brief. See, this is the power of court. Only court. It applies only to the courts. Nobody else can exercise this power. Okay. During an inquiry or trial, whenever court is conducting a trial, it can exercise this power. In one scenario, it has an option to exercise this power, and in the other scenario, the judge is duty bound, statute bound to exercise this power. Without going into the intricacies of it, just understand this section as a bridge between the accused and the court. So this is that section in which the court can actually call the accused and say that I am going to ask you a few questions, please answer them. This can be related to any part of the case. Although this section says that the judge has to question him generally on the case, it actually means that every aspect of the case should be considered while drafting these questions that you're going to ask the accused person. So what is the power of the court under this section? The court can anytime, whenever this inquiry or trial is going on, can call the accused and say that please answer these questions. It is upon the accused to answer them or not. Nobody is going to say anything if the accused chooses to stay silent during this examination. This is the first part of subsection 1, and this is optional on the part of the court. If the court wants, then the court may call the accused. If the court doesn't think that it is required, then there is no mandatory duty cast on the court to call the accused. But at a specific stage, the statute CrPC section 313 has given a mandatory duty to the judge. And that stage is once the prosecution evidence is done. So charge has been framed. Now prosecution evidence have been completed. After that, defense evidence have not yet been started. So the accused has not yet started giving anything in his defense. At that point, as soon as the prosecution evidence gets completed, the prosecution witnesses are examined completely. After that, the court is duty bound, because this section uses the word shall in that scenario. The section says that, listen, Mr. Judge, you are duty bound to call the accused to your court and ask him certain questions about the case. Tell him that these are the evidence that have been laid against you, that have been put into the court against you. These are the people who have deposed against you. Witnesses have said so and so things against you, and this will lead to your conviction. What do you have to say about it? So, although this section does not tell what kind of questions should be asked, but there are judgments which lay down criteria, which lay down guiding rules to frame questionnaires in this regard. Now, there is one very important aspect. Whenever a person is called into the court to depose something, to say something, an oath is administered to that person. You must have seen that Gita ki kasam khao part in movies, but in this section that kasam khao part is missing. So no oath is administered if an accused is being examined under this section. That means if there is no oath being administered, that clearly means that whatever the accused says under this section, under examination under this section, is not considered, will not be considered as an evidence under the Indian Evidence Act. Because if you're not saying it on oath, that means you cannot be cross-examined. If that cannot be cross-examined, that is not a piece of evidence. That is not a piece of substantial evidence at all. This can very well be understood if you read section 3 of the Indian Evidence Act. Now, if I move to the other part of the section, it also says that if the accused says that I do not want to answer these questions or answer any question falsely, even if the court later gets to know that he lied in that situation, he cannot be tried for perjury. He cannot be punished for not saying anything or for lying upon any aspect. Now, the next part of this subsection may look very confusing to some people. It says that if you're giving a statement when you're being examined under section 313 of CrPC, that statement cannot be used against you in that particular case in which you are being examined. But if you say something of that sort which can be used against you in some other case, in some other trial, in some other offense, then it can be used against you in that offense, not in this offense. Okay, so this clearly means that whatever statement comes by the accused under the examination which is conducted under section 313 CrPC is not a piece of substantial evidence, is not that kind of evidence which can be used to solely convict the accused person. Okay, so this cannot be the sole basis for conviction of any accused person. There is a new part which has been inserted into this section in the year 2009, and earlier this section used to cast a duty on the judges, on the presiding officers of the court, to ask questions to the accused persons. But you know the condition of courts these days, you know there is heavy pendency, you know there's a lot of work with even the judges, and that is why this new section was introduced, where the statute says that the judge may seek help from either the defense counsel or the public prosecutor in framing those questions. If you think that these are just one or two questions, if you think that the judge only asks, okay, have you committed the crime? No. Okay, were you there at the scene? No. Okay, and then it concludes. It doesn't happen like that. Actually, there is a set of, you can say that there is even a set of 150 questions in a lot of cases. In the recent Supreme Court judgment that got delivered in March only, there was a set of, I remember, around 95 to 100 questions. This much is required from the courts. Therefore, this section has now empowered the courts to take help from the lawyers in case they wish to take help. And there is also one more new provision that has come up, and that is, if the accused wants, then he can also opt for giving a written statement to all the questions that have been framed against him. The accused can write it down and give it to the court. It saves the time of the court. It helps in reducing pendency, because think of a situation where on a date judge is absent, or but the questions have been prepared. So instead of wasting that day, the accused can say that, okay, give me these questions and I'll give a written statement as an answer to these questions. So time can definitely be saved. Also, you know that many a times in a summons cases are those cases where imprisonment of less than 2 years or just 2 years is given as punishment. So many a times during the trial of summon cases, personal presence of the accused in the courts is not required. The court many a times exempt that presence and just says that you do not need to come to the court, just send your advocate to the court on each date. Similarly, if a trial in a summons case is being conducted and then prosecution evidence gets over, then if the accused thinks that he or she cannot come to the court, then his or her personal attendance can again be dispensed with. But at one point, if you're telling the court that, I cannot come to the court for your 313 examination, then later on you should not go to the higher court or the appellate court saying that I was not examined under section 313 CRPC and therefore I have been convicted wrongly and therefore please acquit me. The trial court will not listen to such requests, because you were the one who said that I cannot come to the court when you were called to the court for a 313 examination. So that is something you need to understand if you are saying no to the court. Can you understand why there is a provision like 313 CRPC? See, the real reason is because it is, first of all, it is to promote hearing the accused. So the concept of natural justice, which is very well known as odi alterum partem. Okay, no one should be convicted unheard, no one should go unheard. So the court has to establish a link between the court and the accused while examining him under section 313 CRPC, and it has to ensure that the accused knows what is happening, that the accused knows what are the kind of evidence that have been put against him, what are the kind of statements that have been given against him, and the court has to ensure that accused answers these questions, or at least the court makes all attempts to make the accused answer this question. The court has to see that these questions are being asked in a very simple manner. The court has to see that if the accused is illiterate, or if the accused is a rustic person, if the accused belongs to a village, then explain all the questions to that person in the language he understands. But the thing is that he should be able to understand each and every aspect of the case. This is also particularly helpful in scenarios where an accused may not have an advocate representing him. So the kind of questions that the court needs to ask the accused is about his case. Let's say there is a trial being conducted for a murder of a girl who was killed by a gun. So the first question can be whether you were present on the spot of the accident on such and such date. Where were you at that time? So the accused may answer that either I don't know, or I was not present there, if the accused has taken a plea of alibi. But the accused has to be very clear in his answers. Now the next question may be that a gun has been recovered from your home. How did that gun reach your home? The accused may say in his defense that there was no gun recovered from my home, and the police officer has some personal enmity with me. We were old neighbors and we had this fight over our land or something, and therefore he has framed this false case against me, although I'm not the real accused. So this is how the examination goes on in under this section. Now you have to also ask him about the statements. Now, if there are many statements that have been made against him, ask him why these PW1, PW2, why all these witnesses are deposing against you. Why do you think that the court should not believe them? What was the purpose? If he has, admitted some part of the crime, then ask the accused, what is the purpose for which you committed this crime? The primary focus of the court, of the judge, should be to find out the true intent of the accused, the nature of crime committed by the accused, the nature of injury imposed by the accused, and the nature of his intent as well. One more thing, many a times the judges also ask the accused persons about their own statements, accused's own statements that may have been made under section 161 CRPC also. So the court may ask, why did you say that thing in front of the police officer in the thana, or anywhere you met that police officer? So the accused may say that, no, I never said that thing. I've already told you that a false case has been made against me and I'm innocent in this case. If there is any confession that has been disclosed in the charge sheet, if a police officer says in his charge sheet that he confessed it before me, there was an extrajudicial confession, or even if there was a judicial confession, then ask the accused person, if you say that you are not guilty, then why did you make that confession? So these are the kind of questions that the judges will ask you. I am telling you all of this because I understand that people who are in the audience may also be advocates, or maybe people who are going to become advocates. So I am telling you all the kind of questions that I have seen, that I know, that I have read about, and how you should approach them. Also, if there are more than one accused, there are, let's say, 4 or 5 accused, then the judge has a responsibility to question all of them specifically and separately. The judge cannot create a chaos in the courtroom by haphazardly questioning one accused and then questioning the third one, or asking one question, same question to all of the accused, and not ensuring that everybody is understanding what the judge is saying. So this is a kind of a responsibility on the court to make the accused understand the circumstances that he is in. Now think of a situation where the accused is convicted on a certain ground, and that ground was never discussed in 313 CRPC examination. The judge failed to even bring up that point on which he convicted the accused person later. That conviction will never be considered as a proper conviction, because you cannot convict an accused on something that was never explained to him. You had the responsibility of explaining every circumstance to him. Now I have a few questions, doubts that a lot of people ask about section 313 CRPC, and I'll be telling you about them one by one. So first question is, what is the effect of court not asking enough question to explain all evidence against accused? So court failed to ask all the questions and then later on convicted the accused. So the answer is, all these circumstances which are not put to the accused, which are not told to the accused, which are not asked from the accused in his examination under 313 CRPC cannot be the basis of conviction of the accused person. This is not something that I am saying, but there is a judgment of 2013 Supreme Court. The name is Rajkumar Singh alias Raju versus State of Rajasthan, AIR 2013 Supreme Court. And recently also in 2022, Supreme Court gave another judgment with respect to this, where the Supreme Court said that the conviction was not proper because section 313 examination was not conducted in a proper manner. That was a 3-judge bench judgment, Jaiprakash Tiwari versus State of MP. It was delivered by the Supreme Court on 4th of August 2022. In case you want to read that judgment, you may go ahead. You'll easily find it on the Supreme Court's website. Second question, second doubt that is often asked is, if I say something inculpatory under section 313 CRPC examination, can I be held guilty on that sole basis, even if the prosecution did not give enough evidence to prove its case? So the answer is no, you cannot solely be held guilty if you give a statement under section 313 CRPC examination and the prosecution fails to give any evidence on that aspect. For example, if it is very clear in the case that you did not commit a murder, there is no evidence against you, the prosecution has no case against you, no prima facie evidence, no witnesses, nothing, and then you go to the court and you say something which is self-harming. For example, you say that I committed this murder. Nothing can be done against you. You cannot be convicted on this sole ground. See, 313 statements are such statements which can only be used as a corroborating or supporting evidence. If prosecution has a story which is similar to your version which you are giving under 313 CRPC, and the court thinks that, okay, prosecution has given enough evidences to prove beyond reasonable doubt that the accused is guilty of the offense they're claiming he's guilty of, then only you can be convicted, or an accused can be convicted under section 313 CRPC. Again, this is not what I am saying, but this was also said in many of the judgments, many judgments, where the court said that statements under section 313 CRPC cannot be treated as substantive evidences, and it can never be a substitute for prosecution evidence. This was laid down in a 2002 case, which is AIR 2002, Supreme Court, Mohan Singh versus Prem Singh and another. So this is a provision which has been put in the Criminal Procedure Code to ensure that a fair trial is conducted, to ensure that an opportunity is given to all the accused persons to explain themselves, to explain those kind of facts which may specially be within the knowledge of the accused persons. And judges are considered to be responsible enough to understand from the conduct of the accused, from what he says in his statement under 313 CRPC, to understand whether he is guilty of the offense, what is the extent of crime committed by him. Sometimes it may be very clear to the court that the accused is guilty. Prosecution evidences may be strong enough. But even in that case, the court will have to later on decide what should be the extent of punishment that should be imposed on the accused person. Examination under section 313 CRPC will also enable the court to understand that properly. How much punishment should I give? If there is a maximum punishment of 10 years in a particular case, how much punishment should I impose in this case? What will be fair? So the court will have to see all these circumstances, all the statements of the accused, to give a fair trial to the accused, to give a fair judgment in the case, and to ensure that trust of the people is maintained in the judiciary of this nation. With this, I just hope that you have understood this section completely. I made this video specifically in the English language because I know there are a lot of law students, lawyers watching from across India. This video is being watched by many people from across India and from our neighboring countries as well. And I wanted to cater to all of you. I also cater to all those people who say that we are from North India and we'd like to have more videos where I'm speaking more of Hindi. This one is for a specific set of audience. Let me know if you like the video. Let me know if all your doubts with respect to this section have been cleared. Let me know if you have any further doubts. I'd be more than happy to answer them in the comment section. With this, I can just say that I'll meet you very soon with a new video on a new concept. Bye for now.